Hello, and thank you for visiting Graphene Business Law. If you're new to our channel, please go ahead and click on the red subscribe button down below and give this video a thumbs up. Here at Graphene, we regularly post content that is most relevant to business owners, and we do also have a few other series on this channel, including videos that are helpful to law students, recent legislative summaries and updates, and case summaries here and there, just to mention a few other kinds of videos that we post here. Today's video is directed to business owners and people curious about starting their own business and entering into contracts and setting up their new businesses. Graphene Business Law, of course, is able to assist you virtually all across Ontario with business law needs, including the launching, the growth, and the conclusion or the wrap-up of your small business. You can always email us at info@graphenebusinesslaw.ca. And of course, you can look down in the description box for other ways to contact us and for a brief write-up of this video as well. Now, many times I find that when persons with business aspirations or individuals with business aspirations come our way, they have a head full of dreams, and which is amazing, and they are so eager to get started in their business dealings and partner with whoever they can and purchase from whoever they can in terms of setting up those vendor agreements or those buyer agreements. And I think there's a lot that is influenced by what one might see online or in movies or in shows about, you know, the complexities and the jargon found in contracts. But these same individuals coming our way, I think, could really benefit from starting with first principles when it comes to contracts and the contracts they might be entering. And I think any lawyer or law school professor or business person would be remiss to not start at the beginning, if you will, of contract formation, which is that of the elements of offer and acceptance. And in today's video, I wanted to focus particularly on the element of acceptance, providing a brief overview. This is certainly not legal advice. This is not me telling you what to do. This is more, you know, educational purposes, giving you a background as to what business persons that might be more ahead of the game than you mean, as to what legal professionals might mean, as to what other, you know, professionals helping you in setting up your business and these first agreements or contracts might mean when they speak. You know, well, have you passed offer and acceptance? Has there been offer and acceptance? Has the deal, you know, firmed up, so to speak, which can only be done through offer and acceptance. And with that being said, I've got a few cases here, I've got an overview, and you'll see me looking at my notes from time to time in explaining to you the big picture of offer and acceptance, again, focusing specifically on what constitutes or what can constitute acceptance in this video. Generally speaking, and this is really big picture, when seeing if there's been acceptance, we're looking at if the person that is deemed to have accepted, or if the person that's being pointed to and told, you know, you accepted, if that person intended to enter into the contract at hand, if they intended to accept. Now, this might be you, this might be a business partner, this might be somebody selling you something you got a really good deal on, and you have this idea in your head that they accepted, and you know they're going to deliver the good or the service to you for this really good price you found. Well, the first thing to keep in mind is whether it's you or someone else in the picture, was there an intention to accept? Next, we're going to be looking at what terms you accepted, and I'll touch on this later on. So in other words, did you accept based on the terms that were mentioned between the parties, or are you thinking you've accepted this, you know, different version of the offer in your head, And different doesn't need to be really different. It can be even a little bit different, might constitute a completely different set of terms that the person offering, the deal to you, so to speak, might not, you guys might not be talking about the same thing. So did you intend to accept, and what do you think you're accepting? Is it the same terms as the offerer believes they've offered you? And then the third big picture aspect is that you accepted in a way that has been communicated to the offeror. So in terms of what methods there are to communicate, again, I'll expand on this a little bit later as well, but you can communicate. There are cases where it's been found that one communicated through actions. There's cases where we've seen that somebody has been deemed to communicate verbally, of course, through words, and certainly there's cases where people have been found to have communicated in writing, right? Now, moving on a little bit to some cases, of course, in a common law jurisdiction like Ontario do really help us understand the law and legal principles, in this case, the principle of acceptance. Looking at a case called the Queen and Clark, and this is actually from the High Court of Australia, but sometimes Canadian jurisdictions do turn to Australia, England, America, whatever the case may be, because they're also common law jurisdictions. We see in this case that one, in order to constitute valid acceptance of the offer, one must be seen to acting in response to the offer, and that one cannot be said to have accepted the offer if they don't even know there was an offer, if one is not acting in response to the actual offer made. And also we see here that the acceptance of an offer must be communicated to the offerer, like actually communicated from person to the other, or from one individual to the other, to the offerer making the offer, unless it's made very clear by the offerer that communication was, that he didn't require a formal notice of acceptance. We see other cases. This next one is called Goldthorpe and Logan, that a contract is valid if the acceptance is communicated by the defendant even through her conduct, so through her action. In this case, remember at the beginning I mentioned there's three big picture ways in terms of actions, words, and writing to accept an offer. And in this case, it was found that the woman in question accepted an offer made to her simply by acting on the offer. And on the other hand, now we see that if the offerer is acting in a way that is indicative of an offer being made, and you move on that, you pay them or whatever the case may be, you deliver a good or a product, then that is deemed to be sufficient acceptance as well, coming out of an offer made through actions, which is important. Important as well is, and we see in a case titled Feldhaus and Bindley, that acceptance cannot be assumed if there's no notification of the acceptance, or not even any implied acceptance through the actions. So silence, total silence, does not amount to acceptance. Again, acceptance needs to be communicated, actions, words, in writing, in one of those ways. And of course, the more clearly the acceptance is communicated, the stronger case you'll have that, for example, you found this really good deal as a small business owner, and you did your part, you paid the other party for it, and now they're not delivering what you believe they offered and you accepted for them to deliver based on a certain price, by way of example. We also see here, remember at the beginning we mentioned that it's important that the party accepting the offer is accepting the actual offer made, which sounds silly, but that comes into play, and that aspect of actual offer becomes pertinent when we're looking at something called counter offers. I'll likely make another video on this at some point down the road, but counter offers, for example, when one party offers you, show up on Thursday to pick up this good for this price, and you say, yeah, I'll show up, but Friday only and for this price. So you might be thinking, you've said, yeah, I'll show up. And somewhere in there, of course, you threw in a different price and a different day and different terms. But don't confuse yourself in thinking that because you've done the yeah, I'll show up part, that you have accepted something, and that what you believe to be acceptance of certain terms has been understood or conveyed to the other party. Because that's an example, and it's a very loose example, but that's an example of a counter offer. You have changed terms, you've made your own offer with your own terms, and in effect, you are not accepting the actual offer made to you. Now, what that counter offer does is it actually serves as a rejection of the offer made to you. That, in legal speak, is your way of saying no thank you to the initial offer made to you. And then you top that no thank you with some desire to perhaps continue communications and make your own amended offer, if you will. But now your counter offer is at the mercy, if you will, of the initial offeror accepting your counter offer, right? You've in effect made your own offer. It's called a counter offer. And you have not accepted the initial terms by saying, yeah, but, okay? So when there's a but and terms are being tweaked, it is likely going to be seen as a counter offer or an offer made from scratch. I'll leave the video there. You can always email us, as I mentioned at the beginning, info@graphenebusinesslaw.ca if you are about to enter into a new contract with any new dealer, supplier, business partner, anybody that you will be working with, providing goods and services to, or paying for their goods and services. Or if you feel that, maybe unfortunately you've entered into something that isn't being honored by the other party, or you don't feel sure about anymore, we certainly can help you here at Graphene understand if there was ever offer and acceptance to begin with, or to draft up a piece of offer and acceptance, and also help you understand what your rights are if you're in a situation regarding offer and acceptance that you might no longer feel comfortable with or wanting to move forward with. Offer and acceptance, those two aspects, again, I don't know that any lawyer or law professor or law academic or professional in any capacity would tell you that an offer or a contract, rather, a successful contract can exist without actual offer and acceptance. So these are really important principles, and today we've touched a little bit on the big picture of acceptance. Thank you for watching, and I look forward to the next video we discuss. Thank you.